The record on appeal consists of 1. The notice of appeal. 2. The judgment roll. 3. Corrected transcript or statement pursuant to 5525. 4. Any relevant exhibits or copies of them. 5. Any reviewable order. And 6. Any opinions on the case. The record on appeal from an interlocutory order consists of notice of appeal, the papers and other exhibits upon which the judgment or order was founded, any opinions, the transcript, if any, and a copy of the judgment appeal from. So there's 5 for an interlocutory appeal because you don't have the judgment roll. Otherwise, it's the same. You can also have statement in lieu of record on appeal. And it may include portions of the testimony, but it shall include the notice of appeal and a copy of the judgment appeal from. It has to include the notice of appeal and a copy of the judgment appeals from. This is all in 5527. Then it says within 20 days after the appellant has taken her appeal, the statement shall be presented to the trial court. So, the statement shall be presented to the trial court within 20 days. The appellant, so if I'm appealing a case, I have to, and we agree, we just want the legal issues decided. So we all, me and the other parties, we agree that this is what we're appealing. We're going to only have like these couple of legal issues reviewed. So we prepare a statement together, and then within 20 days after I filed the notice of appeal, I have to present this statement to the trial court. And the trial court can make changes on it if they want to. And the approved statement shall be printed as a joint appendix. Okay, so again, it is the notice of appeal, the judgment roll, the corrected transcript or statement, any reviewable order, copy of the judgment or order appealed from, and any opinions on the case. That's the 6. And then the only difference between that and the interlocutory record on appeal is that you don't have the judgment roll. Now I'm going to go to 5530. So still, if you went with the whole idea that in civil, if you're not sure, guess 20 days in civil, well, here's more 20-day rule. So this 20-day rule is in 5530, and they're talking about filing, record, and briefs. Service of briefs. A, generally, within 20 days after settlement of the transcript or the statement, or the approval of the statement in lieu of the record on appeal, the appellant shall file the required numbers of copies of her brief. So copies of her brief, that's within 20 days. She has to file with the... All right, so who can I be suing this time? I'll be suing... I'm going to sue Leah Sophia and their bullshit ass lifetime guarantee my ass with a bunch of shitty ass base metals anyway. So I'm suing Leah Sophia and somehow they win. So now I want to appeal. So I'm going to go file my record on appeal, which was those 6 things, or I'm going to get up with their lawyers and be like, hey, listen, let's just, go with these legal issues and let's agree that this is the only issues we care about appealing. I think I'm going to win anyway. So I got to file copies of my brief within 20 days after the statement has been approved. So I had 20 days after I filed my notice of appeal to go and present our statement in lieu of record on appeal, which was pursuant to 5527. So now, pursuant to 5530, after that's all done, whether it was a record on appeal or a statement in lieu of appeal, I have to, within 20 days of it being approved, I have to file my briefs. So I'm going to file them with the clerk, appellate clerk. So I'm going to file them with Christine, the appellate clerk, Christine. I file them, my copies, and then Leah Sophia has 15 days after I serve Leah Sophia with my briefs. They have 15 days to respond. I get their briefs. I'm like, this is bullshit. I have 10 days then to file a reply brief. I'm filing the required number of copies, and then I have to serve Leah Sophia's attorneys with 3 copies of my brief. And then within 15 days, they have to respond to my brief, and then I get 10 days for a reply brief. The time rules then for the regular record on appeal, it's 20-15-10. But for a cross appeal, the time rules are 15-15-10. Unless the court to which the appeals are taken orders otherwise, where both parties take an appeal from the same judgment, the plaintiff or appellant in the court from which the appeal is taken shall file and serve her brief first. The answering brief shall be filed and served within 15 days after service of the first brief and shall include the points and arguments on the cross appeal. A reply brief shall be filed and served within 15 days after service of the answering brief and shall include answering points and arguments on the cross appeal. A reply brief to the cross appeal may thereafter be served and filed within 10 days after service of the reply to the first brief. So there's like a shitload of time rules in appeals. I know this. But basically, so far what I've got is 30 days for the regular appeal. For a motion for permission to appeal, it's the time rules are 30, 8, 15, 10. And then for the statement, it's 20-day rule. Then for the briefs, it's 20, 15, 10. But for cross appeal briefs, it's 15, 15, 10. 5528. Contents of briefs and appendices. A. Appellant's brief and appendix. The brief of the appellant shall contain in the following orders. This is what I got to put in mind. 1. Table of contents with references to the direct, cross, and redirect of each witness. 2. A concise statement not exceeding 2 pages of the questions involved without names, dates, amounts, or particulars, with each question numbered, set forth separately and immediately followed by the answer, if any, of the court from which the appeal is taken. 3. A concise statement of the nature of the case and of the facts which should be known to determine the questions involved, with supporting references to pages in the appendix. 4. The argument for the appellant, which shall be divided into points by appropriate headings distinctively printed. 5. An appendix which may be separate, containing only parts of the record that are necessary for the questions involved. Provided, however, that the appellate division may by rule make different stuff, I guess. Respondents. So now this is Leah Sophia's brief. They have to conform to the requirements of sub A, except that a counter statement of the questions involved or a counter statement of the nature and facts shall be included only if the respondent disagrees with the statement of the appellant and appendix, shall contain only such additional parts of the record as are necessary to consider the questions involved. Any reply brief shall conform to sub A without repetition. Joint appendix may be used separately bound. It shall be filed with appellant's brief. There can be sanctions. Then they got the rules about the papers and a little blurb here with the citations. New York decisions shall be cited from the official reports, if any. All other decisions shall be cited from the official reports, if any, and also from the National Reporter System if they are there reported. Decisions not reported officially or in the National Reporter System shall be cited from the most available source. F. Questions and answers. The answer to a question in the appendix shall not begin a new paragraph. Description of action. So I got to file, together with my record on appeal in both criminal and civil actions, a statement containing the information in the following order. 1. Index number. 2. Full names of the original parties and any change. 3. Court and county. Action commenced. 4. Date action was commenced. Date each pleading was served. 5. Description of the object and nature. 6. A statement as to whether the appeal is from a judgment or order or both. Dates of entry on each judgment or order appealed from in the name of the judge or justice who directed the entry of the judgment. 7. A statement as to the method of appeal being used. A. Whether the appeal is on the full record printed or reproduced, or B. On the original record, in which event state whether the appendix method is being used, or leave to prosecute the appeal on the original method was granted by court or by statute. The statement shall be prefixed to the papers constituting the record on appeal. A copy of this statement shall be filed with the clerk at the time the record on appeal is filed. Something about 5 days there. Hold on. What the fuck? I don't remember any 5 days. Oh, the stay. 5017. A judgment roll consists of the summons, the pleadings, admissions, each judgment, and each order involving the merits and necessarily affecting the final judgment. If the judgment was taken by default, it shall also contain the proof required by 3215 sub F, and the result of any assessment, account, or reference under sub B of 3215. The judgment roll, when it's by confession, under 3218 shall consist of the affidavit and a copy of the judgment. If a trial was had, it shall also contain the verdict or decision, any tender or offer made, and any transcript of proceedings then on file. If an appeal was taken, it shall contain the determination and opinion of each appellate court and the papers upon which the appeal was heard. In action to recover a chattel, it shall also contain the sheriff's return. A judgment roll in a criminal action. When there's restitution order to be paid, the judgment roll consists of just a copy of the order directing the guy to pay, or girl, to pay restitution. And that is filed, supposed to be by the DA, with the county clerk